Hi, everyone. Thank you for joining us today for Constangy's webinar, The Ins and Outs of Paid and Protective Leave. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave time to answer your questions. This program is approved for Sherman HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Joey and Gary.
Good afternoon. My name is Gary Wheeler, and I'm here with Joey Mackey. We're excited to have you here today to share what we hope is going to be some helpful information with you about paid and protected leave. We picked this time of year to have this presentation for a couple of reasons. One is most state legislatures have finished their sessions for the year. And so we're no longer aiming at a moving target. We kind of know what the legislation has been for 2023 and can deal with that. And the second reason is based on our experience in HR professionals usually are working on rolling out new policies for 2024. And so we thought this would be an excellent time for this particular presentation. So hopefully you'll find it helpful today. There is a close relationship between paid and protected leave laws and employee handbook provisions. Employees typically want to know some common answers to questions about how much time they have off, when they're eligible, if they need to obtain permission to get leave in the first place, who to ask, whether they'll be paid, and even if they're not paid, whether their job will be protected or they'll be at risk. And so I have a strong suspicion that these paid and protected leave policies are probably the most utilized policies in a typical employee handbook. By the end of this session, our goal is for you to be able to create a checklist about paid protected leave and to have some actionable ideas how to address those issues within your organization. Today, the things we're going to cover, we're going to talk about some common questions that HR personnel have about paid and protected leave. We'll provide an overview of employers' paid and protected leave obligations under federal law, state law, and some local laws. We'll focus on certain leave laws and policies. I think it's important to have some concrete examples to go over, even though it's going to be impossible to hit on, even a plurality of the policies that you might encounter. It is important to focus on some actual policies, and we'll do that. And then we'll discuss some drafting and compliance approaches that you may find helpful about how to, take legislation and make it part of a policy. So, okay, well, let's get started. A couple of slides ago, I shared a few common questions that employees are likely to have about paid and protected leave. Well, you as their participants are also employees, but your particular audience, the HR professionals, I expect, and you probably have some more pointed questions like these. How do we keep our employee handbook current? Which employee leaves of absence are legally protected? When must leave be paid and when it is only a matter of discretion? That's like a company policy versus actually required by law. And when can employees be disciplined because of poor attendance? If we're providing this leave, can you discipline an employee because they're missing work? What happens if we as an employer make a mistake? What are the best courses of action if you are pretty sure that a mistake has been made? So, the next question is, well, how do we tackle this topic? Now, here is a fairly scary looking slide, and let's talk about this. These are I've basically gone through employee handbooks that we've created for clients over the years and kind of tried to distill all the paid and protected leave policies by the various names that they have and came up with this list of 48. Now, this may not be an exhaustive list, but it's a pretty substantial list nonetheless. And so there's a few reasons that this list may not be as daunting as it initially seems. One is that depending on your situation, where your organization operates, many of these policies may not be applicable to you. There are, obviously these are drawn from all 50 states. Some states are much more active with legislation that has to do with leave than others, and some have very, very few policies regarding employee leave. So depending on that, only a small portion of these policies may apply to your organization. Okay, so that's one reason it may not be as daunting as it seems. Second, as you can see, there are some policies that are quite similar here. For example, there are three policies I'll call your attention to. There's a policy in the middle of the bottom row called legislative leave. There's also on the next column something called political leave. And then the final column, there's something called State Board of Commission leave. All three of these policies obviously are different, but they're very, very similar in their content. The legislative leave policy is in response to legislation from Nevada. The political leave policy is in response to legislation by Minnesota. And the State Board of Commission leave is in response to legislation from Oregon. And they're closely related policies. Basically, these policies are designed to provide protected time off for employees to serve in some type of public service, whether it's in the state legislature or some kind of commission. But they're all relatively short policies, narrow in scope, but because of the very different nature of those state legislatures, the content is different. But in other words, if you have a geographic footprint that involves a number of states, you're going to begin to get the hang of how to adopt these policies, and you'll see that a lot of policies are very similar despite different names. Okay. There's one in the far right column at the very top called small necessities leave. Just keep that in mind. I'm gonna follow up on that a little bit later and discuss that a little bit more. But it's kind of an odd sounding policy, but I do want to get back to the small necessities leave policy in just a little bit. Okay, well, because of the sheer volume of leave policies that are out there, not all of them are utilized at the same rate. This illustration is meant to show the base of this triangle is meant to illustrate the policies that we believe are more frequently used by employees as a whole: sick, vacation, FMLA, bereavement, and maternity, paternity type policies. Now, the policies at the tip of this illustration, civil air patrol, military leave, jury duty, voting, and blood donation, those are the type of policies that are less frequently used, either because there are fewer employees who are eligible for it, or in the case of voting, it seems like that voting in most states has many options available outside of work time. So we find that and of course the area in between is what we would deem to be, these are used more frequently than the tip, but less frequently than the base of the triangle. But we're going to be focusing mainly on the policies that are kind of at the bottom for illustration purposes, because we think these are the policies where if you're starting a project, our recommendation would be that you address these policies first as a priority. Yeah. Well, let's start with the FMLA. This slide sets out the general purpose of the FMLA. Allow employees to attend to important personal needs without fear of losing their job. The vast majority of the time, we as employers want to give employees the leave time they need, and most of the time, employees are grateful for having the time they need, and overall morale is better. Now, the FMLA went into effect in 1993. While there are a few state statutes regarding paid and protected leave that went into effect prior to 1993, there's only a few. I've counted 3 that I can find. There's family leave policies in New Jersey that went into effect in 1990, Oregon in 1991, and California in 1992. But for the most part, I think one of the helpful things about focusing on the FMLA is that it helps set up a framework that's going to become familiar to you in dealing with these other policies. So here are the basics with regard to FMLA. Entitlement, an employee has to be employed for a year. They have to have worked at least 1,250 hours in the last 12 months with the employer. And there have to be, if the employee is going to utilize the FMLA, there have to be 50 employees within 75-mile radius. 75-mile radius is, Google Maps would measure, is the way that that works. And there has to be a protected need for leave, which we'll expand on in a later slide. But one thing to take note of is this framework, which is, hey, are you entitled to FMLA leave? It's going to become familiar. You're going to see it in other legislation and other policies. Is there a length of employment threshold? Is there an hours worked threshold? Is there a minimum of employees that either have to work for an organization as a whole or at a facility specifically? And finally, are there any limitations about the reasons for leave? And in most of the cases, there are. So, okay. How much time off? The FMLA allows 12 weeks of leave typically, but 26 weeks of leave for service members of the military. It can be taken in a block, intermittent, or in reduced time, depending on the circumstances. So, for example, intermittent leave can be taken for an employee's own serious health condition, but cannot be taken intermittently for taking care of obligations related to childbirth or adoption. Okay. The FMLA only provides unpaid leave, but there are some times where it could, in fact, turn out to be paid leave. If employee has paid leave that's been accrued, then of course the employee can use the accrued leave during the otherwise unpaid time period. If the employee is missing work because they're receiving workers' compensation benefits, they may also be being paid some or all of their salary. And the employee may also be receiving some kind of short-term disability benefits for the condition that necessitates the leave. So generally it's unpaid, but there are occasions where it would be paid. Okay. Okay. These are the qualifying events. Earlier, I said one of the bullet points was, is the leave protected? And here are the events that are protected. I won't read them all through, but there's birth or adoption, to care for an immediate family member with a serious health condition, because of your own serious health condition if you're the employee, or for qualifying exigencies that are related to a call to active duty, or a call to active duty status as a member of the National Guard, Reserves, or Armed Forces. Just as an aside, remember when we were looking at the slide with the 48 separate policies on there, and I asked you to remember the small necessities leave? Well, the Small Necessities Leave Act was passed by the Massachusetts state legislature and went into effect in 1998. Remember, the FMLA went into effect in 1993. So as far as I can tell, this the Small Necessities Leave Act was one of the earlier occasions where a state legislature essentially what I would call supplemented the FMLA by expanding the reasons for protected leave and making it applicable to employees who work in Massachusetts in this case. What the Small Necessities Leave Act in Massachusetts provides is 24 hours of job protected leave for a child's school activities, such as a parent-teacher conference, a child's medical appointments, or an elderly relative's medical appointments. So in some other states, you'll find that there are similar protections under their legislation, and it may be swept into a family medical leave act of that state or a school leave act of that state. But this Small Necessities Leave Act is actually one of the earlier kind of state paid leave acts, or unpaid leave acts. So, all right, on to the next one. So what you do in the case of you receive notice that the employee is entitled to FMLA leave. If that employee is eligible, you permit them to take the covered leave. You reinstate them to the same position once they return from leave. And then the things that you would avoid doing are not interfering with the FMLA leave entitlement, which could include denying the leave when there's no legitimate basis for denying it. It could be calling the employee into work when they're scheduled to be off work for a period of time, and don't retaliate against the employee for exercising the FMLA leave. And retaliation under the law means that any act that is likely to dissuade a reasonable worker from exercising his or her rights under the FMLA. Okay. Now here is a helpful guide. Just kind of goes through sequentially what you need to do under the FMLA. Provide notice. And this is done kind of two ways. One is the post and distribute employee rights and responsibilities under the FMLA. This will be the poster that is put up in the break room, but it'll also be your handbook provisions that are hopefully part of your employee handbook. So now once you provide what's called general notice, then you have to listen carefully to employees who may request FMLA leave. Now, they don't have to use the magic words of FMLA leave, but if they put you on notice that they have a need for leave that may qualify for any of the provisions that we just discussed, then it's the employer's duty to respond to the employee's cues here. So this does require some training level, quite honestly, from not only the HR staff, but those supervisory staff that are going to be responding to employees that are discussing absences. So evaluate the employee's needs, and as a consequence, you may provide notice of eligibility rights and responsibilities form, and request a certification form from the employee. And based on that information, decide, designate, and communicate what their rights and responsibilities are as somebody who qualifies for leave. And communicate with the employee while they're out. If their projected leave is 8 weeks, and their 8 weeks is coming up, I would not recommend waiting until 7.9 weeks have passed before you reach out to the employee. So it makes sense to reach out to the employee to make sure he or she is still on target to come back, and to open that lines of communication with that employee, and then return that employee to work, extend leave if necessary or appropriate, or terminate them in the event that they don't return to work, or cannot return to work, and there's not some kind of accommodation that you can make for them under the ADA, or you don't have some other obligation under state law. Okay, so all right. One of the other federal laws we wanted to talk about was the Pregnant Workers Fairness Act. Now, we're bringing this to your attention for a couple of reasons. It was enacted earlier this year, in June of 2023, and its aim is to promote women's health and economic security by ensuring reasonable workplace accommodations for pregnant employees. It applies to employers with 15 or more employees, and requires that employers provide reasonable accommodation to a worker's known limitations related to pregnancy, childbirth, or related medical conditions. Now, potential time off may be considered a reasonable accommodation. That's why we're covering it today, in addition to the fact that it's so recent. A prohibition may be put into place. A prohibition to place a covered employee on leave instead of providing a reasonable accommodation is prohibited. So, in other words, an employer just can't toss your hands up and say, well, this is frustrating, I don't know what would work. Why don't you just take time off? Now, it may be appropriate to take time off, but an employer shouldn't arrive at that conclusion without thinking it through and discussing it with the employee. If it's not his or her preference, some other form of accommodation would probably be more appropriate. Okay, so employers are required to provide accommodations under the Pregnancy Workers Fairness Act unless it would cause an undue hardship on the employer, its operations, and an undue hardship is a significant difficulty or expense for the employer. So that's a difficult standard to meet. Okay. The House Committee on Education and Labor reports on the Pregnancy Workers Fairness Act provides several possible examples of reasonable accommodations. I won't go through them all, but as you can see, we've highlighted in bold, taking leave or time off to recover from childbirth is a form of accommodation. So even though this is an accommodation statute, it is a form of protected leave as well. So that's why we covered it today. Okay. What else does the Pregnancy Workers Fairness Act prohibit? You can't retaliate against an employee for reporting or opposing unlawful discrimination under the Pregnancy Workers Fairness Act. And that would also include somebody participating in investigation, say they made a report to the EEOC. And we've already talked about requiring leave when some other accommodation would be more appropriate and desired by the employee. Okay, well, I'm going to turn it over to Joey now, and he's going to cover some of the state policies and legislation that prompted those policies. Joey?
Yeah, thanks, Gary. So what we're going to cover here in this section is paid leave in America. So what we've done is we've highlighted all the states that we have found that have some type of law on the books that implicates paid leave. And you can see we've divided it into about 4 different colors. So we've divided it, we've tell that there's about 4 different groups out there. So you'll see with Nevada and Maine and then Illinois, those are all paid leave for any reason. The blues, which is Arizona, New Mexico, and Michigan, those are paid leave for sick, medical. And then the greens, which you can see on the West Coast, a little bit in the middle and the Northeast, that is mandatory paid leave for family and medical reasons. And then down more to the South, and then also a little bit up there in Vermont and New Hampshire, that is voluntary paid leave for family and medical reasons. We'll talk about all these in more detail, but just to leave you with this nugget, when you hear voluntary, I just want you to think private insurance as compared to mandatory, which is more like a state law. But so let's dive into the first one, which is paid leave for any reason, which is on the next slide. Gary, could you? So these are the 3 states in America that have paid leave for any reason. And I want to highlight Illinois specifically and get into a little bit more of the details. We can't go through all the exceptions and all of the ordinances in Illinois, but I wanted to give you at least an idea of what this looks like. And the other 2 states are kind of similar as well. So here in Illinois, the first thing you should know is that it actually comes online at the beginning of 2024. So this law, this paid leave for any reason law, comes online on January 1st, 2024. Now the question is, okay, who does this law apply to? It applies to every employee in Illinois that's doing business for an employer that also does business in Illinois. Makes sense. So it doesn't matter if you're full-time, part-time, seasonal. If you are an employee in Illinois, working in Illinois, this law will apply to you. There are, of course, some exceptions, one being those employees that are covered under a collective bargaining agreement or CBA. Those are left out. So then the next question would be, okay, so I'm covered by this paid leave law in Illinois. How much is paid? In Illinois, it's 100% of the wages or full hourly wage. So if it's you will be entitled to take leave, it will be paid, and you will receive 100% of your hourly rate. If you are a salary employee, they just do a formula basically that divides it out per week and then per hour, and that's how they arrive at their hourly rate. But the way you are entitled to this leave, there's 2 methods. One is the accrual method, where an employee essentially for every 40 hours worked, essentially think about a work week, they get 1 hour of paid leave. So if they work a week, then they accumulate 1 hour of paid leave. And then that adds up all the way to the maximum of 40 hours. So in Illinois, you are entitled up to 40 hours of paid leave for a year. Essentially, if you want to think about it, every employee in Illinois is entitled to 1 week of paid leave for any reason. The other option for how, and this might be the more efficient option looking at it through the employer perspective, is they could simply front load it. So at the beginning of every year, or when you hire a new employee, you can just give them the option, like, here's your 40 hours of state guaranteed paid leave. use it at your discretion instead of having to keep track of when they work, how much they work, and then adding the 1 hour per 40 hours. So you can either front load it or you can track it. An employee in Illinois becomes eligible for this after their 90th day of working. So they thought about, they're trying to avoid the scenario, I imagine, where you hire a new employee and then the second week they try to take a whole week off or something. So it seems like they have to at least work 3 months before they get entitled to their state leave. And like I said, the qualifying reason for this type of leave is for any reason. And they also don't have to give the reason to the employer. They just have to give reasonable notice. And since this is such a new law, they're still working out all the details. Their Department of Labor is, but they have already acknowledged that the employer should be able to set some parameters about when or how an employee can take it. They specifically gave an example of, imagine a scenario where you have an hourly employee who does a no-call, no-show. Are they then allowed to retroactively come in the next day and say, oh yeah, that yesterday I was going to use my paid leave? They probably said no, that probably would not be allowed. So it seems like there is some type of notice requirement that they're going to enforce if an employee wants to use their paid leave. But so that's the first group, and it applies to these 3 states. That's paid leave for any reason. The next group, which is on the next slide, is paid sick leave. So if we could transfer perfect, these are Arizona, New Mexico, and Michigan. And this is very similar to the paid leave for any reason. I'll highlight New Mexico for our example. So New Mexico's paid sick leave law went into effect July 1st, 2021. And again, in New Mexico, it covers all employees. Essentially, if you work in New Mexico, regardless of size of the employer, you're entitled to this paid sick leave policy. It works extremely similar to what we just talked about, but instead for this one, there's a little more restrictions on what it can be used for. It essentially could be used for the employee's medical condition or a family member's medical condition and all the things related to that. This also includes events related to domestic or sexual violence as well. And in New Mexico, just for the details, it is also a 100% wage replacement. And they also increased it from, so in Illinois, it was 40 hours that you could bank. In New Mexico, you can bank up to 64 hours, which I think is about a week and a half. So in New Mexico, you get a little bit more guaranteed paid leave, but you're restricted on what you can use it for. You can only use it for sick leave as compared to in Illinois, where you could just use it for vacation. So then our next category is, which is on the next slide, is mandatory paid family medical leave. And you can see here, just as a note too, if you're looking at this map, the darker green states, like for example, California, those are states that the laws are already in effect. And the lighter green states like Colorado and Minnesota, and you can see over there in Maryland and Delaware, those are laws that will be coming online in the future. And so I wanted to focus in on Colorado for this group of paid leave states. Colorado, just like Illinois, this law is going to go online on January 1st, 2024. So this is mandatory paid family medical leave. So there's, similar to the events that Gary was just talking about under the federal FMLA, there's certain qualifying events that an employee could use to qualify for this. Those qualifying events are, for example, care for a new child, including adoption or foster. So just that's maternity or parental leave, care for oneself, care for another family member, and then also making arrangements for family members' military deployment, and also safety need, which is the domestic violence or sexual violence purposes as well. So those are the events that an employee could use this type of leave for. And then the main difference between the paid family medical leave and those other 2 groups is the rate of wage replacement and the length of it. So a big picture here is with the paid family medical leave, it will last much longer. but your wage will not be replaced at 100%. So we'll take Colorado as the example. Someone in Colorado could take up to 12 weeks of paid leave, and those who experience pregnancy or childbirth complications may receive an additional 4 weeks. So in theory, someone could take up to 16 weeks of paid leave in Colorado. But their wage replacement benefits will be paid up to a rate of 90%. It's kind of like a sliding scale, up to 90%. However, there is a cap of $1,100 per week in Colorado. So you could take a pregnant woman who might have experienced some difficulties, could take up to 16 weeks, and she will, and let's say she's a high earner, she will be being paid out $1,100 per week during those 16 weeks. And just so everyone knows for who gets covered under this law, because the Colorado board presented an interesting hypothetical, and I want to touch on it. So clearly, if it's a Colorado business with Colorado employees, everyone's going to be covered. As in, all the employees have the right to this type of protected leave. If the business is located outside of Colorado and they have employees in Colorado, then it gets a little more complicated, and they do this minimum contacts test, which some of y'all might be familiar with. But essentially, if the business is doing sufficient business in Colorado, then the Colorado employees will be covered under this law. And then the third example was if the employee is in Colorado working remotely for a business outside of Colorado that does no business in Colorado at all, so the remote employee truly is fully remote, it is unlikely that that employee would be covered by this law. So just keep that in mind, depending on wherever your business or headquarters is located, and if you have states, or if you have employees across the state, it's really just depends on where you do business in each one of those states and where those employees are located, whether or not these laws apply. Quickly, I just want to show, just so everyone gets an idea of how other states have handled this. They've all tweaked it. It's all the same idea, right? So paid leave for X amount of weeks related to family or medical reasons, but they've all like tweaked the numbers essentially. So, for example, in California, it's up to 8 weeks, so less than Colorado, but it's capped at $1,620 a week, so the cap is higher. So employees could get paid more. And in Oregon, similarly to Colorado, basically applies to all employees. And the minimum wage workers in Oregon get 100% of their wage guaranteed, so more than Colorado. So 100% for minimum wage workers, and then it slides down to 50% the more you make. And that one is capped at about $1,500 a week. So the big takeaway from this slide is just if you understand federal FMLA laws, then you should be okay with these ones. Just understand that even though you have less than 50 employees, you'll probably still fall within these categories, because most of these states have done away with any type of employer size requirement. It basically covers any employee for any size. And then there is some type of payment that will have to be made. And just the final note on this is, well, how is this all paid? Where does this money come from? At least in Colorado, it is a 0.9% wage tax shared by both the employer and the employee. So it's paid through state taxes for most of these states. And as compared to the next group, which is on the next slide, if we could make, this is the voluntary paid family medical leave group. And like I said at the beginning, the big takeaway here is I just want you to think that for these states, this is all about private insurance. So, and we'll look at Florida specifically, the state I'm most familiar with. They just passed it's House Bill 721 that went into effect on May 25th, 2023. So just this year. So here in Florida, and I'm sure it's like this in most states, insurance is heavily regulated. An insurance company can only sell certain type of products like life insurance, property insurance, those type of things. So what they've done here in Florida is they've created or they've now allowed for a new product to be sold in the state, and that product is paid family medical leave. So the way it works is whether the employee wants to go out and buy this type of insurance on their own, or if the employer wants to get a group policy and offer it to everybody, all their employees, as an optional type of coverage. An employee in Florida will now have the option to basically buy insurance that will cover the same exact things that traditional family medical leave are for. Just so we get on the same page, it's for the birth of a child, adoption of a child by the employee, care of an employee's family member, or care for the employee themselves. And then also similarly with the military active duty service and things related to domestic and sexual violence. So the qualifying events are all the same. And a big note here, though, is when they were doing the bill analysis, they did say, notably, the bill does not create a right to paid family leave benefits for employees. So there's no state right to paid benefit leaves in Florida. And rather, the bill does not create that right to employees that are not eligible under FMLA. So essentially, from the employer's perspective, with this new law, you really don't, if you didn't qualify under federal FMLA, then you really don't have to worry about this new law coming into effect. If you already if you were big enough and you did qualify under federal FMLA, now essentially you just need to be aware that you don't have to offer it, but you could offer a paid family medical leave insurance group policy through AFLAC or the Hartford or something like that. The same thing I'm sure that some people do, like with additional insurance coverage, like disability or something like that. So that's that ends these groups. But again, so I think the big takeaway here is just so everyone gets an idea of where the legislators have gone in the country. They've essentially either said, okay, we'll give you employees and mandate employers to give, we'll call it short-term paid leave for any reason or for any sick leave reason, and that employee gets 100% of their wages. So as a reminder, in Illinois, they get 100% of the wages, but it's only up for a week and they can use it for any reason. Or they'll do what they've done basically on the West Coast and the Northeast, which is state mandated paid family medical leave, which is not 100% of your wages, but it lasts significantly longer, up to 12, 16 weeks. And then you have what they've done primarily down in the South, which is put the option more on the private insurance market. So the employers or employees have the options to either offer or buy insurance that will cover the same things as paid family medical leave. But that is the end of our overview for the paid leave in America on a state basis. So I will be turning it now back over to Gary to talk about leave policies on the city or municipality level. Oh, hey, Gary, I'm sorry. I think you're muted.
Okay, thanks, Joey. I do want to just briefly talk about 4 additional new state laws or recent amendments. One is Maine. They have a paid family medical leave program that won't actually be going into effect until January of 2026. But in January 2025, employers will begin to have a payroll tax implemented, which will be split between employers and employees to fund that family medical leave program. In Maryland, they adopted a family medical leave program. The employee contributions begin October of next year, and employees may begin using benefits in 2026. New Hampshire has a nursing mothers are entitled to unpaid breaks of 30 minutes to pump for every 3 hours. That will be beginning in July of 2025. So you do see that there are times to ramp up for these new laws. Oregon, just wanted to call your attention. They had a new law that prohibits employers from requiring employees to use vacation, sick, or annual leave for time that the employee spends as an appointed member of a state board or commission. Okay, that went into effect just a few months ago in September of 2023. So those are just a couple of other state laws I wanted to call your attention to, since they're basically recently enacted or recently passed. Okay. Well, now, so besides states and the federal government passing laws that impact paid leave, there are cities or counties, municipalities that have paid leave provisions that may in some cases be more generous to the employee than those under state law. So basically, if you're in any of these cities, and I'm going to share 2 more slides with you, there are 8 states. So California, Illinois, and Maryland all have at least one city. And California has, as you can see, many cities where there's enhanced benefits to employees that work within the city limits of these municipalities. Now, you'll see that there's also some in Minnesota, New Mexico, New York, Pennsylvania, some municipalities there, and finally in Washington. The interesting part about that is you need to keep, if you have employees working from home who live in these cities and move elsewhere, you want to make sure that you stay up to date on that, because your obligations may become different if employee is living in Seattle versus the suburbs of Seattle, which is not technically Seattle anymore. Then that obligation may either come online or go away, depending on whether the employee moves in or out of the Seattle city limit. So it does require kind of not only a compliance standpoint, but better communication between the employer and the employee about where they live, because that impacts their benefits. Okay. All right. So I did want to talk about some drafting and compliance best practices as you kind of come out of this and decide what policies you may need to revise or implement. So if you're a multi-state employer, consider state supplements. This is typically what in most cases I'll advise clients to do, is to have state supplements for each of the states that they operate in. The alternative to that, and some employers do this, is you can carefully draft policies to comply with multiple states. This is, of course, easier to do if you have fewer states. Then there's not as many moving parts. Then you could potentially draft a policy where it captures all the required elements of the state legislation that's at issue. So on a kind of related note, since your employee benefits entitlements are likely to be different depending on where you operate, you may want to decide how the employee handbook will be disseminated. One approach, which is probably the easiest from an administrative standpoint, is to just have all the state supplements at the back and distribute the same handbook to all employees. Another approach would be to deliver a customized handbook to the employees in a particular state. So let's say if you have 7 employees in Louisiana, you would provide the core handbook plus the Louisiana supplement to those 7 employees. And those would be the only supplement that they would get at that location. So that's another approach. I think that makes it easier. There's less room for confusion, but it is a little bit more of an administrative hassle to do it that way. Okay. Another suggestion is consider the employee handbook as an ongoing project. Most legislation, as I showed a few slides ago, provide some lead time for compliance. There were a few that we showed that don't really go into effect until 2025 or 2026. So you'll have time to draft those policies. Another one is to share the joy of this compliance task with more than just one person. Take a team approach to this. It's probably much easier to miss your compliance obligations if you do not have but only one person handling this task. So my recommendation is to have some degree of overlap to make sure that nothing gets missed with regard to these policies. Another idea is that I think that people are starting to use the ChatGPT AI tool, and it's funny how quickly we get used to new technology. And I find that the ChatGPT could be helpful in drafting these policies, or being assistant to draft policies. I still find about 20% of the time the chat will miss something that is in a statute or misinterpret the statute, but 80% of the time it's good, and I think it's an excellent tool to help give you a first draft or to check your work. So I'd encourage you to at least consider using something like ChatGPT to help you with these projects where there's no really extra credit given for originality. It's these are compliance policies, pretty dry and boring, but you want to make sure that you've covered your bases. Okay. All right. So I just want to address a question that came in the chat while Joey and I were discussing this. What if an employer is in Missouri but has employees working remotely in Illinois? Do we have to comply with the Illinois law? Yes. So that is an occasion where we're finding more and more employers have 1 or 2 employees in a state, and they're working in that state. They're generally employees. The compliance obligation you'll have will be of that employee working in that particular state. So you would need a supplement for Illinois if the employers and the other employees are based in Missouri. So good question. All right, and let's see, we've got another. What about all the gray states? The gray states are states where there wasn't any particular state law that impacted that state. So just to go back and show you an example from Joey's slide. This is mandatory paid family medical leave. Texas, Florida, they simply don't have any mandatory paid family medical leave. Okay. Now again, these are state laws. Of course, everybody is subject if they're large enough and they have 50 or more employees within 75 miles of the work site. They have to comply with the Family Medical Leave Act. But these gray states don't have any paid family medical leave. But as you're making your to-do list, you want to make sure that they're gray in all categories, because we go back and we go on this one, it changed. Like Arizona and New Mexico don't have any paid family medical leave, but they do have paid sick leave. So your obligations are different to pay based on the type of paid and protected leave. Okay. Let's see. For the Chicago ordinance, how does it work for field employees who are offices are not within Chicago, but they are working on site in Chicago for the majority of their work hours? Okay. So I don't have that Chicago ordinance before me, but most of those talk about the number of hours that are actually the work is conducted in that municipality. And so that employee would likely meet that that requirement and be covered under whatever Chicago's paid leave does. Okay, if we share the most up-to-date workplace posters, do we have to include in the handbook? Again, this varies by state. Most states do not require that you have a written policy regarding these. You have the compliance obligation, obviously, but not necessarily a policy. There are some exceptions, though. There are some legislation where no good deed goes unpunished, and it basically reads something like the effect of, to the extent the employer has a handbook, if you have a handbook, then this policy must be included in the handbook. So sometimes you'll have an obligation to include a policy because you already have a handbook. Right? Is it legal to not hire someone based on what state they are from? Yes. So I understand the reason for this question may be, okay, well, it's going to be onerous for us to comply with this particular state's laws. They've got a lot of laws. Yes, but there's not an obligation that you allow employees to work in a particular state. And if you, as an organization, decide, well, we love California, but it's very onerous to have employees there, you could decide just not to hire employees there. Okay, you mentioned that if a person is covered under a collective bargaining agreement, that they are exempt from the state rules. Could you expand on that a bit? We operate in Florida and have fully remote workers in states such as California, New Jersey, et cetera, but they are covered under a collective bargaining agreement. We do not operate in this states. Could singular persons be in that state? Okay. Unfortunately, I'm not going to be able to get into that, but you're welcome to reach out to me. But that was something Joey covered. I want to make sure that I don't misstate what was going on there. For the Pregnant Workers Fairness Act, would a reasonable accommodation include work from home? So would there be a limit on the duration, and would it be still applicable following the birth of the child? Okay, okay, so for the second part, would it be applicable based after the birth of the child? There are regulations that are being developed right now, and so I don't know. The jury's still out on that, whether it would be applicable after the birth of the child. But for at least some period of time, I suspect that it will be. It's work from home. It is a possible accommodation for sure. Definitely work from home. Doesn't mean under your circumstances it would have to be granted, but I would definitely have that as do the state-based changes affect independent contractors as well? No, the independent contractors are really not subject to employment laws and really shouldn't be receiving employee handbooks. They should be treated. They should not. Yeah, they're not subject to employment laws, really. So, okay. Well, I appreciate our time together, and hope you found this helpful. And I do want to share one more thing with you regarding the certification credits. So let's make sure we get those to you. Here are the SHRM and HRCI numbers for making sure you get the credit you need, and please jot those down or get these off of the PowerPoint that we'll distribute to you afterwards. So again, the PowerPoint and a recorded version of this are going to be available, and we appreciate your time. Thank you very much. Bye-bye.